Massachusetts is facing a mounting crisis as public defenders stage a walkout over pay disputes, resulting in defendants, including some accused of violent crimes, being released. Can you explain how this standoff unfolded and why it's reached such a critical point?
Certainly. The public defender system in Massachusetts is under immense strain due to stagnant wages and overwhelming caseloads. When defenders refused new assignments, courts were left with no legal representation for indigent defendants, forcing judges to release individuals to avoid violating their constitutional rights to counsel.
That's alarming. From a legal infrastructure perspective, what does it mean when the system fails to provide counsel? Are we witnessing a constitutional crisis?
Absolutely. This is a slow-motion constitutional crisis. The Sixth Amendment guarantees the right to counsel. When the state can't meet this obligation, it calls into question the legitimacy of criminal proceedings and exposes deep structural weaknesses in state budgeting and resource allocation.
In light of these releases, the public is understandably concerned about safety. How are communities reacting, and what are the broader implications for trust in the justice system?
There's significant anxiety. Some communities feel betrayed, fearing that dangerous individuals are being let go due to bureaucratic failures. Trust in the courts erodes when victims and the public see the justice system unable to function, potentially fueling cycles of crime and undermining deterrence.
Are there any analogous situations in other states or countries that might shed light on potential long-term effects?
Yes, similar crises in Louisiana and the UK have shown that once public trust is lost, it's difficult to restore. In Louisiana, for example, crime victims often felt abandoned, while public defenders faced burnout and attrition, compounding the crisis.
Transitioning to the root causes, how does state budgeting contribute to this crisis, and what inequities are being highlighted in Massachusetts?
The disconnect is stark. Public defense is chronically underfunded compared to prosecution. In Massachusetts, prosecutors may earn 30% more than defenders, despite similar workloads. This pay gap, combined with rising caseloads, disproportionately affects low-income defendants and exacerbates existing social inequities.
Given that, what reforms are being proposed? And are there any models of success elsewhere?
Some advocate for statutory pay parity and workload caps. New York City, for instance, implemented reforms raising defender pay and saw reduced turnover. However, scaling such models statewide requires sustained political will and funding.
Shifting to immigration, the Supreme Court's recent decision removed judicial oversight from certain deportations, leading to the expulsion of 8 violent offenders to South Sudan. What legal precedent does this set regarding executive power?
This ruling marks a significant expansion of executive discretion. By curtailing judicial review, the court handed DHS broad authority to deport individuals without court intervention, raising concerns about checks and balances and due process for non-citizens.
How have human rights advocates and immigration lawyers responded to this development?
Many are alarmed. Advocacy groups argue that such unchecked power undermines basic protections against wrongful deportation, especially for vulnerable populations. They fear this could become a template for future executive actions bypassing the judiciary.
Balancing national security and due process is always contentious. Supporters of the ruling claim it enhances public safety by swiftly removing dangerous individuals. How do you evaluate these competing priorities?
It's a classic tension. While swift action may address immediate threats, history shows that sacrificing due process can lead to wrongful removals and international criticism. The 1996 Anti-Terrorism Act, for instance, led to several high-profile deportations later found unjustified.
Could this approach backfire diplomatically or domestically?
Absolutely. South Sudan has limited capacity to absorb returnees, and abrupt removals may strain diplomatic relations. Domestically, it risks eroding the image of fair, rule-bound immigration enforcement.
Turning to civil law, the Federal Circuit's decision in Igenera v. Cisco reinforced strict standards for patent claim amendments. What's the significance for tech companies and innovators?
This ruling signals that the judiciary is no longer tolerant of ambiguous or evolving patent claims. For startups, it means greater clarity is required from the outset, but it also raises the barrier to entry by increasing the legal sophistication needed to protect new inventions.
Is there a risk this could stifle innovation, particularly among smaller firms?
Indeed, while large corporations can afford specialized counsel, smaller entities may struggle to navigate these complex standards, potentially discouraging them from pursuing valuable IP protections.
To put this in perspective, how does the U.S. approach to patent litigation compare to global counterparts, like the EU or Japan?
The U.S. is notably litigious, with over 4 zero-patent cases filed annually. The EU, by contrast, uses centralized courts and has stricter filters for what constitutes a patentable invention. Japanese courts are known for efficiency but grant fewer damages, making their system less adversarial.
Does this create competitive advantages or disadvantages for American innovators?
There's a trade-off. The U.S. system offers robust protections but at high cost. For some, this encourages aggressive innovation. For others, it creates a legal minefield that can deter market entry.
Let's ground this with real-world examples. How have recent patent rulings shaped the startup landscape, especially in fields like biotech or software?
In biotech, rigid patent standards have pushed some startups to partner early with larger firms, trading equity for legal support. In software, the Supreme Court's Alice decision led to a 63% drop in software-related patent filings, signaling that unclear claims simply won't hold up in court.
What strategies are startups using to adapt?
Many are focusing on trade secrets or open-source models, while others invest heavily in upfront patent drafting to withstand judicial scrutiny. The landscape is evolving rapidly as legal risks become central to business planning.
Now, let's turn to judicial accountability. The tribunal investigating Judge Mbeneng in South Africa over sexual harassment allegations is making headlines. What's at stake in this case?
This tribunal isn't just about individual conduct. It's a litmus test for judicial integrity and the willingness of legal institutions to address abuse of power. Given the global Me Too movement, the outcome will signal whether courts can effectively police their own ranks.
How does this compare with similar proceedings in other jurisdictions?
In the U.S., judicial discipline is often handled quietly, while in the UK, public hearings are more common. South Africa's approach, her transparency and public scrutiny may set a new standard in judicial oversight.
This case also spotlights the intersection of power, gender, and institutional culture. How do these dynamics shape the handling of misconduct allegations in the judiciary?
Power imbalances make it difficult for victims to come forward, especially in hierarchical systems. Studies show that only 18% of judicial misconduct complaints globally result in public hearings. Transparent processes like this tribunal can encourage reporting and deter future abuses.
What reforms could strengthen accountability and support survivors?
Mandatory reporting, independent oversight bodies, and whistleblower protections are key. International best practices suggest that regular ethics training and external audits can further bolster judicial integrity.